20 days. 20 days are what are left for NLSAT 2026. In these 20 days, I know we have had a lot of practice sessions for Part A. But you guys always had this request. Keep Part B legal answer writing. We need a one shot for the same. And I completely understand the need for the same. As in, by going so much deeper into current affairs, general knowledge, and all of that stuff, you guys now have an idea about how you can go about essay writing. But still, we need fine tunings in that as well. But right now, you guys have an idea कि essay writing को कैसे deal करना है. Part B legal answer writing is still something that a lot of you guys are perplexed with. Majority of whom have started the preparation in the last 2 or 3 months, and I completely understand that, because understand all of us come from a very different background. A few of us are engineers, a few of us are have had undergraduate degrees in humanities, biotechnology, commerce, across different streams. But when we come onto this, we can easily tackle, not exactly easily, but with some amount of practice, we can tackle the part A. With some amount of awareness, we can tackle the essay writing. But part B legal answer writing is a skill that you need to understand that why is it being tested in this particular exam. So for the people who have started their preparation very recently, understand that how Part B legal answer writing looks like and how it will look at you. By the time you reach your Part B legal answer writing, which we always advise to go get done with your Part A first, by the time you reach your Part B, the first thing you put across is 5 questions. 5 questions, 12 marks each. 5 questions and 12 mark each. What is the speciality about these 5 questions? In these 5 questions, there will be hypotheticals about different states, different cities, or different territories, different sovereign entities. Some kind of act they have started up with, some kind of per se something has happened therein, and you are told, okay, now adjudicate liability. Now adjudicate. If you are not adjudicate liability, give your judgment or give your decision in this matter. These kind of questions, understand what they want out of you. They want to test that beyond reading long paragraphs, beyond critical thinking, beyond having general awareness, do you guys also have that legal taint, arguing like a lawyer? Do you guys have the ability to go ahead and criticize something? Do you guys have the ability to extract important things from a particular there's a particular question matrix? And in addition to that, also the ability, they want to see that if you guys have the ability to argue like a lawyer. Understand that at what juncture you will be put across these kind of questions. By the time you are done with 500 words lamba 7 or 8 passages, and I'm not even accounting for the 7 or 8 questions in each of those passages. 75 questions, 75 MCQ questions you guys have faced at this moment. You guys have solved 75 MCQ questions, that in 65 minutes, 65 to 70 minutes. You are mentally exhausted. You are right now in the that we tell the runner's flow, the dopamine hit when the runners hit that. You are right now, your body is well accustomed, your mind is well accustomed to read content, analyze that content. You are not right now accustomed, as per the framework of the exam and the entire environment, to go ahead and write something as well, to reproduce your own thoughts as well. You are right now accustomed to analyze information and to critically evaluate it. You are not ready to reproduce new information, and that is where they hit you. They now give you some kind of scenario and ask you to reproduce information already when you are in some kind of fatigue. See, you have already consumed, like for part A 70 minutes, for revision if we reserve 10 minutes, and for essay like again 15 minutes. Then in all of this scenario, if we add all of this and subtract it from our 150 minute ka total time, we are left like 50 to 60 minutes. 60 on a very good day, 50 on a decent day for part B legal answer writing. That amounts to like 10 minutes per question. In these 10 minutes, you need to go ahead and read the question. Think about what should I go ahead and write for this particular question. Then write that in a structured manner. Why do I impress so much upon write that in a structured manner? Understand one thing, that why have they? I have already discussed this. Why do they want you to write legal answers? Why do they want you to write legal answers when they explicitly mention that you need not have any prior knowledge of law? When prior knowledge of law is not necessary, prior knowledge is not necessary, then why do they want you to write legal answer? To check if your common sense, the common sense that you are applying to solve these particular problems, is parallel with the ethos of rule of law, as in is parallel with how we perceive justice, how we perceive rule of law, how we perceive these things. Understand that okay, they give you a scenario that okay, this person, there was one car belonging to person A. There was one car belonging to person A. Okay, there is a person B who goes ahead and steals this car from person A. Now B what does, that B sells that car to person C. ठीक है. After 10 years, what happens, that A sees that car on C's porch. A now files a case against C. They now tell you, okay, karo, now adjudicate what will happen. A general person will, maybe a general person, because I have seen students go ahead and what they do is they go ahead and say that okay, what the government should do right now is they should now tell order an investigation against B. They should seek information from C and do all of that. Do all of that. No, this is a general person whining or complaining. This is not how you solve a legal situation. What kind of stuff they want from you? Like, okay, C is a bona fide purchaser. A is commenting after 10 years. His limitation has expired. Something like this. Not exactly. You need not have all the particular statutory knowledge about each of these things to the minutest to the points. But you need to understand how statutes operate. This is something they expect out of you. If you do not mention this, others will and they will get higher marks than you. First things first, what do I call it? I call it the legal flair that you should have in your answers. The legal flair. How do you make it possible that the legal flair is better translated into your paper and is better transcribed onto the mind of the examiner? Understand who are these people who are going to check your copies. These are people who are teaching at NLS, who are legal academicians, who are practicing advocates, all of that sort. The entire legal academia goes ahead and checks your papers. These people throughout the years are accustomed to read all of the content in a particular format. The format we call it as IRAC. In the IRAC format, whenever we are presented against a moot question, any question of law, any question of fact, against a legal question, what do? Out of that question, we derive the issues. Then we come up with the rule of law and characterize it. Then we proceed with our arguments. Then we give a conclusion. Very eloquently mentioned. What are all of these four things? What is issue and what is all of this? Understand what exactly is an issue. Issue are the steps. Issue is not whether A is good or bad. That is generally what will be asked you in the question. Issue are the steps that you employ. With an example that I have quoted a lot of times on this channel and more than that in our batches as well, is understand if the question is Ram and Ravi are two school-going children, can they go to Vizag? The issues herein will be being two school-going children, do Ram and Ravi have the requisite resources to go to Vizag? And similarly, being two school-going children, do they have the requisite permission from their guardians to go to Vizag? Similarly, if the government tomorrow comes up with a law and that law specifically states street hawking, how do you argue against this? You tell that okay, the street hawking is the right to work of these particular people, right to earn their livelihood of these particular people. Immediately counter argument you have to take into account. Government is stopping this for, let's say, traffic congestion बहुत हो रहा है, accident बहुत हो रहा है. How do you go about it? How do you characterize your answers after that? For all of those things, you need to use your tools well. And what are those tools? That is something that we will be learning in this particular lecture. Issue is one of the way you can start your answers with, saying that okay, the issues that I'm going to be dealing with this kind of question are these and these. After that, the second thing you have is your rule of law. Is your rule of law. Understand why do we need a rule of law? Why do we need to have a discussion about the rule of law in the question as well? Because the law is not supreme. The law is, my bad, law is supreme, but the law is not infallible. As in, the law may also falter, the law may also be wrong. Therein we characterize, or therein we challenge the interpretation of the particular law. There will be questions wherein there is a specific statute that has come up very recently. The government is interpreting that statute in a particular way, due to which some kind of person is not facing some kind of problem. Therein you have to go and say that okay, the statute is fundamentally wrong, or even if the statute is not fundamentally wrong, the present interpretation that the government is giving to this statute, that interpretation is wrong, because that interpretation is not doing justice to the intent of the statute, to the intent with which the statute was created. Understood? To the intent with which the statute was created. Then again, we have to go a level deeper. We also have to see in all of these questions the act, the intent of the statute, the stakeholders. How do we say that okay, the statute is not meeting its intent? By saying that okay, the intent of the statute was to protect these particular stakeholders of the society. Given it is a welfare statute, the statute is a welfare one, the statute is a beneficiary one. The point of having such a statute is to benefit these kind of people. It is a beneficial statute. Or in against that, the point of this is a preventive statute. The point of this statute is to prevent some kind of act. So we now need to see that okay, the point of the statute is to prevent these kind of act. If we today allow this kind of this kind of interpretation of the statute, then we are creating a very easy gap around this prevention, in which people might flow, in which the malicious act might flow like this, and the entire intent of the statute will be eroded. This is how you use rule of law in your answers. Then, using arguments based on these things, after characterizing these things, 50% of your job is done, but you need to anchor these things back into your question and then you argue. See, one thing that I always advise against, and one thing I always caution against, is using too much facts in your answers. But you should also refer to the facts sometimes, and that you do while making or presenting your arguments. You say that okay, my argument number one is this, not exactly like this, but present your argument. Then the major and the most important part that you do while writing down your argumentation is not actually presenting good arguments, is presenting good rebuttals to the counter arguments. This shows to the examiner that okay, you have thought this question through and through. Even though you are protecting one side, you take the counter argument, the counter argument, the strongest argument of the other side, and then rebut that. And obviously you need a one-liner conclusion that we see, say the C of the IRAC. Got it? Now I believe I have very well explained to you guys that okay, in what way you need to write a part B legal answer. But understand, why did I say this to you? Because obviously, just bachpan mein, if you do not practice maths enough and just know the theory of how to practice a math equation, if you just know the formula of a plus b ka whole square, a square plus b square plus 2ab, बस ये फॉर्मूला याद करके जाओगे, एग्जाम हॉल में यू विल सिट, एंड इफ उसी फॉर्मूला पे कोई क्वेश्चन आता है, will you be able to solve? No. Although you know the theory, you won't be able to solve. Why? You do not know how to apply that formula. Similarly, when you are mentally fatigued after part A, a question comes, then if you do not know what all things that I have to write in here, you won't be able to write that. I'm framing the issues this and this, but what do you write within that? If you have not come across that type of question before, how do you go ahead and solve it? So understand, by analyzing the previous year papers of NLSAT and by giving NLSAT myself once or twice, I have seen that they have a few repeated types of questions that they ask. Because understand, they tell you that they do not want any kind of statutory knowledge, prior knowledge of law from you. No prior knowledge is required. So they also need to give questions that are agnostic to these kind of statutes. How will they give these questions? By giving questions which are based out of common, for in a colloquial way, commonsensical law. What are those? Tort law ho gaya, infliction of constitutional rights ho gaya, all of those things that all of us are required to, all of us are expected to know. So based on those, these are the four very common types of questions that have been repeated year on year in NLSAT. And we will be solving all of these four kinds of questions. We'll be seeing what kind of issues you will have to frame for these questions. We'll be seeing how do you argument, how do you present your arguments in these kind of questions, how do you argue in these kind of questions, and how do you characterize the rule of law in these kind of questions. So let's go one by one. Number one, the first thing that we see is state versus individual rights. A lot of times question will come something like this. There is a state matlab your government. Government goes ahead and restricts an individual some kind of right. ठीक है? Tomorrow government, the street hawker wala example, restricts a right. Individual's right is restricted. Then you are said ki, okay, defend the individual. Argue from the favor of the individual. What will you argue? What will you argue? Now government did what government did was wrong. Okay. Government did what government did was wrong because individual's right is violated. Okay, but government did it for a reason. Does government not have the power? Was the right that was actually whatever the new law, the legislation, the restriction brought into place, was it done in a foul manner? No, it was done with the assent of the government, all the members of the parliament. What's the problem with that? How do you argue these kind of questions? Therein these tools come up. These tools like reasonableness. These are the doctrines and tools that you can use to argue. Reasonableness. The state action must meet a standard of reasonable necessity. It should be occupied with proper reasons. It should not be arbitrary. What is reasonableness? Reasonable. Non-arbitrary. Non-arbitrary as in whatever the state does, the state should provide proper reasons for that. It should be proportional. Proportional as in if the object behind the legislation was this, then whatever the state does should be in tune with the object of the legislation. The state interest should be legitimate. The state cannot act with a bad thought in mind. The state cannot bring ahead with a legislation with a thought to kill people or proliferate monopolies, something like that. Or least restrictive means, the last thing that we use, least restrictive. Even if it is imminently necessary to put on such kind of restrictions, the state must use the means which are least restrictive. Okay, these are the four things. Let me use this in the form of a question so that you guys understand it better. A hypothetical question could be, in the state of Varuna, a centuries-old religious festival is conducted annually along the banks of river Sthala, where the devotees gather in large numbers to perform ritual offerings. Recently, the State Meteorological Department issued a report predicting unusually heavy rainfall, indicating a significant risk of river overflow and localized flooding. ठीक है. State government issued an executive order prohibiting all religious gatherings. ठीक है. All religious gatherings along the river bank for entire festival month. बहुत लोगों ने चैलेंज किया एक पर्टिकुलर ऑर्डर में द गवर्नमेंट हैज सेड कि where temporary restrictions during emergencies are upheld. ठीक है. What will be the issue here? Issues are very simple. Whether one, the whatever restriction put up by the government were proportional, were proportionate. Did the government put up proportionate restrictions? And number two, did the government Basically, issues can be both. Did the government put up reasonable restrictions and did they put up proportionate restrictions? But here, instance, I am trying to argue for the people of Varuna. I am trying to say that the government did not put up proportionate restrictions. I will use issues that are in favor of me. I will first argue that the restriction that whatever was put was not proportionate, one, and the restriction whatever was put was what? Proportionate में least restrictive means आ जाएगा. Let's go ahead with this. Let's go ahead with this one issue as only. ठीक है. Then I will go ahead and explain. Rule of law, we do not need a lot of analysis of the rule of law herein, but we can just mention the doctrine of proportionality. The doctrine of proportionality demands that any kind of restriction, any kind of restriction that we bring on, that restriction should be least in nature upon the kind of right that was being promulgated and should meet the objective and should not overreach the objective. ठीक है, यहाँ पे मेरे पास दो सिंपल आर्ग्यूमेंट है. Number one argument, what was their reason? I cannot say that the particular thing is not reasonable. I am because they have given reasons. But whatever reasons they have given, have they acted on that? What was the reasons, guys? The reasons were flooding is supposed to happen. Flooding is going to happen. But because flooding is happen, is restriction for the entire month the only way out? Is restriction for the entire month the only way out of this? Think about it. Flooding, the object of the flooding, the object of the particular executive order is that people should be protected from floods. What was the effect? People for protecting them from flood in particular parts of the month, entire month ka all religious proceedings are suspended. Is it good? This now I will tie to my second argument, that least restrictive means should be used. As in, if the government, this I already showed how the government has overreached its object. That is why it is not proportional. And now I will establish how least restrictive means should be used. How do you say that a least restrictive means should be used? You should go ahead and say this. Number one, a least restrictive means could have been on the particular day wherein there are high chances of rainfall, on particular parts of the particular demography, whether it is a state or a village or a city, whatever, and with proper safeguard mechanism could have been given to people, so that even in heavy raining not leading to flood, people could have done that particular legal procession. But the government has not done this. So least restrictive means when they are available, then why do we need a complete blanket ban on any kind of rights? Other side, then you can take because argumentation may also need to take the side of the other party. A cross argument could have been that government has legitimate interest. A government had legitimate interest of protecting the people. The government did not act in bad faith. But again, uska argument yahi hai ki even if the interest was legitimate, the action could have been mitigated by less restrictive means. So how can you structure this answer in the end? Sorry guys, how can you structure this answer in the end? In the end, you can write the answer something like this. First, you explain the issue. First, you give your verdict immediately. That I believe, or that the government should not have done this or should have done this. That the government is wrong, the government is right. Or else the imposition led on by the government is not as per the particular thing and is encroaching upon the rights. Whatever the question has asked, answer that question by giving a verdict. Then frame the issue. What should be a issue? Whether the action of the government is proportionate. Then rule of law. Proportionality means whatever the object of your act is, the object of your act should not be breached by your actions. One. Second, what is the second part about proportionality? A very important part. That the second thing is when there are less restrictive means available, they should be taken. Then arguments. First argument, object of the act. This is the object of the act. Mention that the object of the executive order was this. Then say this. You can also show it in here and here. then mention that this has been breached because a blanket ban has been imposed. Blanket ban has been imposed. Argument number 2, take it as a counter argument. Use this thing. The government says that okay, they have legitimate interest. Even if the government says that they do have legitimate interest, less restrictive means could have used. Khatam question. Second kind of question, negligence and duty of care. Let us understand these concepts a little bit first before directly delving into all of these things. What are the key doctrines that you should know here? Duty of care. Duty of care is an obligation. It is an obligation to avoid any act or omission that could reasonably be foreseen to cause harm to another. You have a duty of care against all of the people who are near you. To what extent does that duty of care go on? Does it extend like infinitely? No. It does not operate like that. Duty of care goes on only. The entire duty of care goes on only till the point a reasonable man could foresee. ठीक है? A reasonable man could foresee. इसका मतलब क्या हो जाता है? That you have a duty of care. Duty of care to do something. Duty of care to do something. Some kind of harm happens. Some kind of harm happens. If when this kind of harm happens was not foreseeable by a reasonable man who will have a similar duty, then the person has not breached his duty of care and is not liable for causing this harm. But if this is foreseeable, the person has breached his duty of care and is thus negligent. Got it? Understood how the issues will go on like. See, in the city of Nayanpur, Raghav hires a private bus service operated by Zenith Travels for a group trip. The driver, Mohan, is experienced and conducts standard pre-trip safety checks. Okay. During the journey, the bus passes through a hilly region known for occasional landslides during the monsoon. Despite clear weather at departure, sudden and unprecedented landslide occurs, causing the bus to swerve and resulting in injuries to several passengers. Claim alleging negligence. Zenith argues that all reasonable precautions were taken. Rely on Kiran versus Safe Transportation Co. Liability was held not to arise from harm caused by unforeseeable natural resources. Why do they give these kind of questions? Mention them while proving the point in the argument. Simple. I am not writing full-fledged answers right now, else I would have also shown how you should write, the kind of words you should use, not these legal doctrinal words, but the kind of words you should use to swerve a teacher with you. That is another thing that you develop. What is the issue here? The issue is not simply that was Raghav negligent, was Mohan negligent. The issue is not simply was Mohan negligent. The issue was whether it was Mohan's duty of care. Whether it was Mohan's... No, my bad. It will be not this as well. The question is whether Mohan breached. Whether Mohan breached his duty of care. The issue is not whether Mohan is negligent, but whether Mohan breached his duty of care. By this, if Mohan breached his duty of care, he is negligent. If he has not breached, he is not negligent. Simple. We then see the acts. The argument number 1, I will be arguing from the favor of Mohan. See, whatever happened there, Mohan, first argument is Mohan met his duty of care. Whatever Mohan's duty of care was, Mohan fulfilled that duty because he departed only after clear weather. He made standard checks. One is clear weather, then is standard checks. Clear weather and standard checks. These are the two things that Mohan eloquently did. Simple. Nothing different. Okay. Second argument could have been Mohan, let's do the counter argument. Mohan is an experienced driver. He should have knowledge about these kind of things happening. Mohan is an experienced driver. He should be careful that okay, no damage happens to the passengers. But what happened? A sudden and unprecedented thing has happened that was not foreseeable by anyone, and use the judgment herein. Not foreseeable by anyone. Thus, due to these reasons, Mohan should not be held liable. Mohan was not negligent. As simple as that. Then there are, guys, third type of questions, purpose based interpretation, wherein you need to interpret the purpose behind a particular legislation. It is very simple to the first kind of question. The only difference between them and this is, therein we had to fight against a state, herein we had to fight against another individual. Herein, see, you have to do a purpose. My bad. Herein, we have to do a purposive interpretation. Okay, this is a different kind of question. That is the fourth kind of question. Now, just a second, guys. Purpose-based questions are slightly different. Purpose-based questions, as I tell it to use, this is the logic of the law. This is the logic of the law. See how you use these kind of questions. Understand that some kind of act has happened, as we were discussing. Government is interpreting it in a certain way, but you believe that this interpretation is not doing any benefit. So you say that do not follow the letter, the bare letter of the law. When you follow the bare letter of the law, you are doing a textual interpretation. A textual interpretation may bypass the purpose for which the law was brought into place. So you need to see the legislative intent, the absurdity doctrine, and the substance over form. You must value the substance of the law over the form in which it is written. Detailed explanation has already been given. Go through that. Question देख लेते हैं. The state of Artha introduced Uniform Commodity Tax Act, which imposes a higher tax rate on processed cubic food. See, processed cubic food products, on the rationale that such items require special storage and logistics. Dispute arises when paneer cubes are classified under this category, taxed at a higher rate. ठीक है. Traders argue paneer being a dairy product at a lower tax bracket, essential food items. State contends that paneer is sold in cube form, satisfies the statutory ये. ठीक है. Prior judgment, classification was aligned with economic function and functional identity. So this kind of question, you need to do a lot of characterization because there are a lot of terms here and there. You need to provide a characterization, you need to provide stakeholders and do all of the work. You need to tell how law should go ahead. This is testing of, okay, do you understand the ethos behind the law? See, when they are saying that this particular cubic thing, the answer should look something like this, slightly away from the issue kind of thing. It should look something like this. Issues can also be formed on this as well. You will form issues, but I am like delineating the entire content, the substance of the answer for you. Whenever they are saying that okay, tax will be levied on cubic things, cubic food items, they are saying that this is only for processed cubic food items. Why? Now cull out the intent. The intent will obviously not be given to you, but cull out the intent. Why? Processed food items which are in cubic shape may mean luxury food item. Luxury food item because they're processed, they're in a particular shape. For this, extra storage, extra facility, extra capital is needed. And to tend for that, the government is taxing. But paneer is an essential food item. It does not fit within this category. So even if it is sold in cubes, it does not need all of the things that are mentioned here in the such extra capital and storage. So why should an extra tax be added? And second, if tomorrow these processed food items are sold in cubes because they can be only sold in cubes, this tax is for things that can be only sold in cubes. If today we put such kind of tax on paneer and deem this tax to be legitimate, so what is going to happen? Tomorrow paneer will be sold in cuboids, easily bypassed. So if it is so easy to bypass this particular interpretation of law, then won't it make the entire interpretation absurd? That is the question. So frame issues like that, characterize the rule of law like that, characterize it like that, then go ahead and produce your arguments. Take up the counter argument as well. What could be the counter argument? The government has come up with this tax bracket, all of that. There should be uniformity. You say, okay, there should be uniformity. We agree. But use this absurdity wala argument, easily bypassable. Got it, guys? Then there is another thing that is an extension of the first kind of question only, competing rights and balancing of those, wherein you need to see, guys, that okay, पिछले वाले type of questions हैं what we saw, that individual is enforcing their rights against the government. Right now there is a tussle of rights between individuals and what rights are fundamental, what rights should be protected while others should be let down. Here it is a general tussle between what rights are more fundamental to the human being. Balancing, when there are two legitimate rights and none of them is absolute, court must weigh the rights, which right is heavier. Proportionality, a restrictions of one right to protect another must be proportionate, not exceeding what is necessary. Necessity and proportionality ka test. And public interest versus private harm, rights serving a broader public interest always have a higher weightage than purely private harm. And based on that, this question is also there. So I believe right now this question is a very simple one. You guys can solve it yourself and write the answer for these questions using the tools that I have given in the comment section. I'll be providing feedback for that as well. But moving away from that, guys, these are the various kinds of questions that we saw in today's one shot. In this one shot, what did we discuss? The structure of part B, legal answer writing, the substance of part B, legal answer writing. You guys know that how to write your answers and what to write in your answers. After this lecture, I believe you're well equipped. Any doubts, give in the comment section. You want to attempt mocks for NLSAT 2026? We have our Law Friend Essentials batch just at rupees 199. You will get 5 high quality lectures, 5 All India full length ranked mock tests. And if you guys are new and unsure about this entire, if you guys can make through NLSAT 2026 or not, there is Law Friends early bird codes for NLSAT 2027, currently at a discounted price. Go check that out. All of these things you guys will find where? www.lawfriend.com. Join in our Telegram group as well, that is the NLSAT one. And yep, as I always say, keep preparing, keep practicing, never forget, aim to be.
Are you preparing for 3-year LLB entrance exams but feeling overwhelmed and unsure where to start? Do you struggle with finding the right resources, guidance and clarity, all in one place? Tired of institutions selling just mock tests or rebranding old materials meant for other exams and charging a fortune for it? Introducing LawFriend, your one-stop solution for 3-year LLB entrance exams. LawFriend brings you cutting-edge tools to supercharge your preparation. With our exams portal, you can participate in live All India tests and instantly see your rank, giving you real-time insights into your performance. Practice questions on individual topics, sharpen your skills, and get exam ready with confidence. LawFriend, aim to be.